In paragraph 2, the respondent number 6 and 9 has been mentioned instead of respondent number 6 and 8. Peruse the records. The order dated, the paragraph 2, the respondent number 6 and 9 in paragraph 2 of order dated 13th of November 2025 is directed to be read as respondent number 6 and 8. Office to carry out the necessary corrections. आपने requisite जमा कर दिया? The requisite so deposited pursuant to order dated 13th of November 2025 is directed to be immediately dispatched.
Item 2, second appeal 399 of 2018.
कोई डेट वगैरह
Date already fixed. इसमें क्या हुआ?
इसमें सेकंड का भी लाइक हो रहा है जो कि जिसके सेपरेट ऑर्डर ऑलरेडी हो चुका
Okay. Second appeal number 399 of 2018. Was it for
है previous statement.
the matter has been listed at the instance of the office. SA 11/2022.
What is
It has been pointed out that SA number 37 of 2020 has been wrongly included in order dated 25/11/2025 passed in SA number 399 of 2018 and analogous cases. A separate order was dictated in SA number 37 of 2020 on the same day. Considering the aforesaid facts, the order dated 25/11/2025 passed in SA number 399 of 2018 is modified, and it is directed that the mention of SA number 37 of 2020 be deleted. Office is directed to carry out the necessary correction in order dated 25/11/2025.
Item 3, second appeal filing number 4772 of 2025.
इसमें भी केस सेकंड अपील 2260 25 इसमें टाइप इसमें सेपरेट ऑलरेडी हो चुका
Filing number SA 4772 of 2025. It has been listed at the instance of the office. It has been pointed out that in order dated 25/11/2025, SA number 6660 of 2025 has been SA filing number होगा ना?
ये फाइलिंग है
SA filing number 6660 of 2025 has been wrongly included, and a separate order has been drawn in filing number SA 6660 of 25. इसका अलग से order है ना? Considering the aforesaid, the order dated 25/11/2025 passed in filing number SA 4772 of 2025 with analogous cases is hereby modified, and filing number SA 6660 of 2025 in the state, as mentioned in the state order, is directed to be deleted. Office to carry out necessary correction in every.
from daily list for final soldier fixed case item 1, second appeal 5/8/1991 along with item 2.
कल एक मेंशन हुआ था, क्या हुआ?
वो है सेट
हाँ, कौन कौन? अदर साइड कहाँ है? कौन कौन?
From supplementary list item 4, second appeal 194 of 2006.
Russian ink was not possible. Three IEs are there. One IE lordship and withdrawing lordship for the that was for a treatment of party lordship. Subsequent procedure were sought to be treated as party lordship. Right? But it's not required.
Which is IE number? He is seeking a password. Please wait for some time there. What time will suit you?
2 to 3 cases. And budget, sir.
12 बजे 12 o'clock.
That will be fine.
From trade list, this case item 1 for 2nd April 58 of 1991 along with item 2.
Essay 58 has been filed by whom?
By defendant.
Only dependent.
Defendant. 1, 3. Yeah, now. Yeah,
1991 filed by defendant number 1 to 3 represented by their legal heirs. इसमें अबेटमेंट का कोई कहानी नहीं है ना? Alright, what is the substantial question of law in Essay 58?
The learned court of appeal below would have passed the improved judgment in regard to plot number 288, plot number 601, 667, and 254 of Khata 89 without considering oral and documentary evidence on the court.
Plot number 210 of Khata number 88
Well,
and plot number
601, 661, and 254, Khata number 89.
the oral and documentary evidences have not been considered at all.
Not considered.
Not at all.
Not at all. With regard to
Just a moment. This is so far as second appeal number 58 of 91 is concerned. What about the other connected appeal? उसका नंबर बताइए.
69, the second appeal of 69 of 1951. The
Plaintiff is the appellant.
plaintiff.
So you are the appellant in this case? Yes, counsel? आप
Yes,
हैं?
yes.
Plaintiff खुद है कि legal heirs हैं?
नहीं हम plaintiff को
Plaintiff is alive.
I'm not sure. Right.
Substituted है.
Substituted.
Admit कब हुआ?
On 14/8/2008, but without formulating substantial question of law. But later on, by order dated 13/8/2025, substantial question of law has also been formulated.
Which order?
Order dated 13/8/2025. Order number 55.
ये टेबल पे ना कुछ ऐसे वाइट ये वाले पेन है, दूसरे एक वाइट कलर पेन राइट हैंड साइड में रखे हम उसको देखते हैं. ओके, व्हाट इज द सब्सटैंशियल क्वेश्चन ऑफ लॉ?
In second case,
यस,
whether the judgment of the learned court below allowing appeal with respect to block number 154, khata number 116, block number 151, khata number 20, block number 623 and 1249, khata number 121, block number 251, khata number 152 of village Burgundy is based on low evidence and is correct.
which is that order?
Order dated 13/8.
Order number 45, Your Lordship.
एक सेकंड. This is lot number 144, khata number 116, lot number 151, khata number 120, number 623, 749, बोथ द दोनों केस में सेम विलेज का प्रॉपर्टी है.
Same village.
विलेज कौन सा है?
Babandi,
भावंडी.
Babandi.
लिखिए जरा, जस्ट second appeal number 58 of 1991 and second appeal number 69 of 1991 have been tagged as this arise out of the same proceedings. Essay number 58 of 1991 has been filed by the defendant number 1 to 3 who are being represented before this court through the legal years. The substantial question of law was framed by the order dated 23/8/1991, which relates to plot number 210 of khata number 88 and plot number 610, 667 and 254 of khata number 89.
The total land is of 6
Just please hold on. The substantial question of law reads as follows. So far as essay number 69 of 1991 is concerned, the same has been filed by the plaintiff and the legal years of the plaintiff are before this court. When the case was admitted on 14/8/2008, no substantial question of law was framed. However, on 13/8/2025, a substantial question of law has been framed. The substantial question of law in 69 of 1991 relates to plot number 144 of khata number 116, semicolon, plot number 151 of khata number 120, semicolon, plot number 623 and 749 of khata number 121 and plot number 251 of khata number 122. The substantial question of law is quoted as under.
total land is 6.18 acres. Lord.
नहीं, अभी आपका बारी नहीं है, अभी इनको बहस का, अभी आप कुछ भी मत बोलो.
हमने कुछ
जब तक हम पूछे नहीं कुछ मत बोलो.
government filed another suit for declaration of their right title and possession over two properties.
Like the plaintiff.
Two properties not in both the appeals properties. For other declaration that their title and possession has not been affected by any order of revenue. Case of complaint of
Just a moment. The suit was filed for declaration of title and possession for the declaration that so for the following relief content. The schedule of the property is also quoted there.
case of the plaintiff that Muhammad Janakarat was performed defendant number 4 below in this suit below was the one co-sharer of its intermediate interest in the government and who in the partition suit number 24 1930.
Give me a brief background and then I will see the records. It just give me a brief background. This Kumar was the co-sharer of
Co-sharer
the entire suit property.
the other suit property is one of the part of suit property is whatever having allotted in the Tatha of Janakarat Kumar. That is was a performance defendant 4. That is the suit property. In the earlier partition suit number 24, 1930, co-sharers. All the
24
co-sharers
of
are not in this
24 of
1930.
प्लेन पढ़िए ऐसे नहीं हो प्लेन पढ़िए तो
Muhammad Janakarat was the former defendant was 4 was the ex-intermediary of village Bandi, Kanpur, district Palamu, who in the partition suit number 24 of 1930, the two the co-sharer landlords of the court of the deputy magistrate subject of Palamu was a defendant number 1, allotted established Tatha hearing number 4, desired others. The lands fully described in the schedule given at the foot of this plan, which will be referred in after the lands of the field. That in Tatha allotted to Proforma defendant number 4, she was allotted beside other lands, block number 210, 667, 601, 254, and Vajiti Khata number 116, 120, 121, 122. The layers of the Vajiti Khata 116, 126, 21, and 122 had announced their holding, and so block number 154 according to Khata number, according to Khata number 116, block number 151, of Khata number 120, block number 623, and 649 of Khata number 121, block number 222, Khata number 22 came in her possession of the Proforma defendant number 4. She had filed a return under section 3B of the BR Act after vesting of the intermediary interest in the state of Bihar, mentioned therein dispute lands and her Batas land in her khas position. She also filed for assessment of rent and her application in form K under the Bill Act must have been considered for initiation of an assessment rent case. In the meantime, the former defendant opposed to a registered sale deed dated 6962 sold block number 210, 667, 601, 254, 154, 151, 653, 149, 251 for valuation and valuable consideration to the plaintiff and put the plaintiff in possession thereof. The former defendant of court had also constructed a house a portion of the plot of 54 which was also sold to the plaintiff. The purchase lands issued. That soon after the purchase, the plaintiff filed an application for assessment of rent in their favor and purchaser in interest of former defendant number 4, which the application was registered at case number 225 of 1962-63. The plaintiff remained in expectation and waited for further proceeding in the aforesaid case, but no intimation or notice was received by the plaintiff. And we are certain that the assessment of in course of time must have been made in their favor, but surprisingly, they came into know in 1970 that assessment was not made till then. She filed of that case was reported to be missing. Thereafter, the plaintiff again filed a petition for expeditious assessment of rent, which the application should have formed part of earlier case number 275/1972, but same wrongly registered and mutation case in number 345 of 1971. The revenue officials also reported the position of the plaintiff, but in the meantime, it transpired to the circle officer that the principal defendants somehow or other have not got the rent of the lands the suit assessed in their name without any basis. As a matter of fact, the principal defendants had or have neither any right, title, or possession over the lands in suit, but the circle officer, under misconception of the law and the facts of the case, instead of assessing rent in favor of the plaintiff, rejected the petition of plaintiff on the pretext that rent of the lands in suit had already been assessed in AR case number 5 and 6 of 1961-62 in the name of principal defendants. That there was no return under section 3B for application in for K under the BR Act filed by principal defendant, and as such states subject before would not any occasion for the assessment of rent in favor of principal defendant, nor the principal defendants any share so far have rejected any basis or basis of which the claim, right, and title over the land issue. As such, if the assessment of rent has been done in favor of principal defendants for the lands in dispute, there must have been without any basis against the provisions of law and national required ab initio. The order which is required need not be set aside, and there is no necessity for the plaintiff to go against the alleged order of assessment in appeal under section 8 of the
Just a moment. No appeal was filed against which case? That was assessment case number?
Assessment case number
5 and 6.
5 and 6 of 1961.
No appeal filed.
No.
Okay. Then
Hence, the plaintiff preferred appeal against the order of the circuit officer.
which is that order of the circle officer? In which case this order was passed? 345. ये 345 कौन सा केस है?
345 तो म्यूटेशन केस फाइल किए थे, प्लेंटिव फाइल किए थे फॉर असेसमेंट ऑफ रेट, एंड 5-6 जो है वो डिफेंडेंट के नाम से असेसमेंट हुआ है 1961-62 में। उसके खिलाफ प्लेंटिव या उनका प्रोसेसर कोई अपील फाइल नहीं किया। इसको बोलता है कि उसको अपील नहीं फाइल किए थे तो उससे कोई उनको दिक्कत नहीं है।
सर पढ़िए पैरा 3 पढ़िए।
Plaintiff preferred appeal against the order of the circuit officer party for case 345 in the additional collector Ramu, but appeal was also dismissed on 79-75. That assessment of restitution of the principal defendant and the order of
ये
the
अपील का नंबर ये क्या है? रोमन 15/74। Order of Revenue Authority even in Revenue Appeal number 15 of 74 of 71-72।
77 ये 345 जो है ये सर्किल ऑफिसर के यहाँ फाइल किए थे जब उनका 275 रिजेक्ट हो गया था सर्किल, तो फिर ये 345 अलग से फाइल किए। बोलता कि उसमें हमको पता नहीं चला क्या ऑर्डर हुआ, उसका पता चला कि मिस कर दिया फाइल, तो फिर सेकंड टाइम फाइल किए 340 फॉर से 340 केस नंबर 345 ऑफ 1971 तो म्यूटेशन the additional collector Palamu, but the appeal was also dismissed। उसको भी रिजेक्ट हो गया था, एडिशनल कलेक्टर क्या अपील फाइल की थी वो भी डिसमिस हो गया। इसका नंबर इसमें नहीं लिखता है, अपील का नंबर नहीं लिखता है। That the assessment of rent, if any, of the principal defendant and the order of the revenue authority even in revenue appeal।
Just hold on, ठीक है, देख लीजिए, लिखिए पंकज। As per the plaint, Mohammed Janak Raj Kumari, the pro forma defendant number 4, was the ex-intermediary of village Bhavandi, PS Chandpur, ex-intermediary लिखा हुआ है, PS Chandpur district Palamu, who in partition suit number 24 of 1930 amongst the co-sharers of the landlord was allotted a separate takka bearing number 4. Besides other lands, the scheduled property of the plaintiff were allocated to her. She was defendant number 1 in partition suit number 24 of 1930. It is the case of the plaintiff that the defendant number 4 was allotted inter alia plot number 210667601-254 and Rayati Khata number 116 120, 121 and 122. It was their further case that the Rayati Khata, the Rayats of the Rayati Khata had abandoned their holding and therefore plot number 144 of Khata number 116, plot number 151 of Khata number 120, plot number 623 and 749 of Khata number 121, and plot number 251 of Khata number 122 came in the exclusive possession of the pro forma defendant number 4. She had filed her return under Section 3B of Bihar Land Reforms Act. And the suit land was her Bakast land and in her caste possession. She had also filed Form K for assessment of rent under BLR Act. it has been stated that her application in Form K for assessment of must have been considered for initiation of an assessment of rent case. However, in the meantime, pro forma depend number 4 through registered CD dated 15/9/62 sold plot number 210-667-601, 254, 154, 151, 623, 749 and 251 to the plaintiff and put the plaintiff in possession.
In virtue of registered sale.
Yes. The pro forma dependent had also constructed a house in a portion of plot number 254, which was also sold to the plaintiff. It was further case of the plaintiff that immediately after purchase, the plaintiff filed application for assessment of rent in their favor as successor in interest of pro forma dependent number 4, which was registered as case number 275 of 1962-63. But the case remained pending and the plaintiff did not receive any notice or intimation. And the plaintiff was of the view that assessment of rent in course of time must have been made in their favor. However, they came to know in the year 1970 that assessment of rent was not made, as the file was missing. Consequently, the plaintiff filed a petition for expeditious assessment of rent. And as per the plaintiff, the new application should have formed a part of the earlier case number 275 of 1962-63, but it was registered as a mutation case number 345 of 1970-71. It was also reported to the plaintiff by the revenue officials that the principal dependent somehow got the rent of the land in the suit assessed in their name without any basis. Although the principal dependent had no right, title or possession with respect to the suit land. In such circumstances, the circle officer, under it has been alleged that under misconception of law, instead of assessing the rent in favor of the plaintiff, rejected the petition filed by the plaintiff on the pretext that the rent of the land with respect to the suit property was already assessed in A.R. case number 5 and 6 of 1961-62 in the name of the principal dependent. The case of the plaintiff is that no return under section 3B or application in form K under BLR Act was filed by the principal dependent, and as such there could have been no occasion to assess the rent in favor of the principal dependent. And the principal dependent had no basis to claim right and title over the suit land. It was alleged that the assessment of rent in favor of the principal dependent was without any basis and was against the provision of law and therefore was void ab initio. It was asserted by the plaintiff that such void order need not be set aside and therefore the plaintiff did not file any appeal against the assessment of rent in favor of the defendant said to have been made in AR case number 5 and 6 of 1961-62. However, the plaintiff preferred appeal against the order of the circle officer refusing to assess rent in favor of the plaintiff, which was numbered as case number 345 of 1970-71 before the learned Additional Collector Palamu, but the appeal was also dismissed on 17/9/75. The plaintiff asserted that the assessment of rent in the name of principal defendant and the order of revenue authorities, even in revenue appeal, passed by the additional collector Palamu, has not affected the right, title and possession of the plaintiff over the suit land. But in order to get the matter settled, the plaintiff found it necessary to file the suit. It was also asserted that पुराना सूट से तो कोई मतलब नहीं,
Which was dismissed on the
That's
ground of non-filing of the court case notice.
it's no filing in the eyes of law. चलिए, अब डिफेंडेंट का केस पढ़िए. Written statement. They filed different written statements. Yeah, one written statement.
Two written statements, one by the performer defendant number 4, Janak Kua, and one by the contesting respondent.
Okay, the contesting defendant number 1 to 3 and the pro forma defendant number 4
Yes.
filed their respective written statements.
The performer defendant number 4 supporting the case of the plaintiff.
Naturally, they will support. उसका तो काम ही है सपोर्ट करना pro forma. चलिए, contesting defendant का केस.
Contesting defendant's case is untenable and it is barred by limitation.
एक सेकंड, पंकज जी, कई वाला जो फाइल था ना, उसको टाइम मिले तो थोड़ा ऊपर से पढ़ लीजिए. हाँ, जो कल जिस स्टेटस में था उसी स्टेटस में है, लेकिन पढ़ लीजिए.
Which is also barred by non-joiner of the necessary party and would be also barred for adversely.
You see, we are not concerned with those matters. Non-joinder of necessary party is not the substantial question of law. जो substantial question of law नहीं है, वो उसके बारे में कुछ मत करना. ठीक है? आगे बढ़ते हैं.
Sought to not the case of the defendant is
What is the basis on which the defendant is claiming title? ये पैरा नंबर 12 से पढ़िए. पैरा 12 से पढ़िए. 12 नंबर.
Say
para 11 that the statement of facts mentioned in the claim are is not admitted by the defendant. Therefore, the plaintiffs are strictly called upon to prove the evidence that the defendant of acts of the statement of facts of claim para 2 are also not admitted by the defendant. The former defendant of 4 was never in possession over an inch of the land of the Bhandi, much less the suit lands at any material time. She is a widow prior to 1922, and her son Pankatesh Narayan Singh died at an early age, and due to the shock of the respective death of her husband and her son, Musoma Janakraj was left the village Bhandi and settled down in village Davra. And thereafter she never allowed to come to the village. That said, Musoma Janakraj never came in village Bhandi, nor came in possession of any of the plot in question. Babu Ram Narayan Singh and the late Babu Jai Mangal Prasad Singh were in possession from the year 1930 And on the death of Babu, their Mangal Singh, his sons, defendant number 1 and 2, and their mother came in possession along with Babu Ram Naresh Singh over the entire Sudan. That defendants have been in possession over the entire Sudan to the knowledge of the plaintiff and before to the knowledge of the former defendant number 4. That neither the plaintiff nor the former defendants have got any kind of concern with the Sudan. The statement of facts mentioned by a 2 are false and imaginary. The return and effort made by performer even show if high, and if the revenue authority could have found the possession of Muhammad and Nagraj Kumar over the food land, they must have been assessed rent in our favor under section 567 of the PRA Act. But as the former defendant had no possession over the food land, even on the date of vesting, that is 26/1/1955. Therefore, the rent was not assessed in her favor. She had no right to dispute a sale deed in favor of the plaintiff. The suit land are in possession of the defendants and the possession of Muhammad Utim Rajkumar, the widow of the Jai Mangal Singh, and in this case, Muhammad Utim Rajkumar is not a party. Hence, the case is back on account of non-joinder and it is fit to be dismissed. That the suit land has been mentioned in peaceful possession of the defendants and the rent for the suit land has been assessed by case number 5 of 1961-62 and further case number 6 of 1961-62 and by case number 1168 of 1955-56 and by case number 1169 of 1955-56 in favor of the defendants by the collector under BLR Act. The statement also realized that the government also realized the rent and granting the rent receipt to the defendants to the knowledge of the former defendant and also the plaintiff. The plaintiff have alleged in part 2 the plaintiff that they purchased the suit land from the former defendant in the year 1962, but then before that year, the rate had already been fixed in the name of the defendants and the government had realized rate, but no appeal under section 8 either filed by the former defendant or by plaintiff. Therefore, the present suit is for setting aside of setting aside or declaration that order passed by the revenue court has not affected the title and possession of the plaintiff as set out in the relief A of the claim is a hopelessly barred by virtue of section 35 of the BLR Act. No suit can be instituted against the circumstances of the case. Therefore, the present suit is fit to be dismissed on this court alone. That the plaintiff has the right, no right title, but much less possession over the suit land through the alleged deed. That the sale deed is in question is a bogus transaction without any consideration. That the plaintiffs have applied for mutation of their names and not for assessment in the year 1962-63, and their case has been registered as
ठीक है,
mutation
देखिए,
case.
देख सुनिए, the contesting defendant filed written statement and inter alia stated that pro forma defendant number 4 was never in possession over the suit land or any land in the concerned village, Bhapati. She was a widow prior to 1922 and her son had died at an early age, due to which she left the village and settled down in village Dabra and was never allowed to return back to the village Barwadi. It was asserted that Babu Ram Naresh Singh and Babu Jaimangal Prasad Singh were in possession right from the year 1930. And on death of Babu Jaimangal Singh, his sons, defend number 1 and 2, and their mother came in possession along with Babu Ram Naresh Singh over the entire Sud property. And they remained in possession to the knowledge of the plaintiff and also to the knowledge of the pro forma defendant number 4. It was asserted that neither the plaintiff nor pro forma defendant number 4 have any kind of concern with the Sud property. It was further case of the contesting defendant that the return and form K alleged to have been filed by the pro forma defendant number 4, if filed, and if the revenue authority would have found them in possession, they must have been assessed for rent in terms of section 5, 6 and 7 of Bihar Land Reforms Act. However, since the pro forma defendant had no possession over the Sud property, even on the date of vesting, that is 26/1/1955, therefore rent was not assessed in her name. Consequently, she had no right to execute any sale deed in favor of the plaintiff. It was also asserted that the Sud land were in possession of these contesting defendants and in possession of Mausamar Uttimraj Kuwar KUER and widow of late Jaimangal Singh, but she was not made party in the case, due to which the case suffered from non-joinder of missing party. It was the case that since the defendants were found in peaceful possession of the Sud property, the rent was assessed in their favor, while case number Roman 5 of 1961-62 and further in case number Roman 6 of 1961-62 and also in case number Roman 6 of 1961-62, it was asserted that in case number 1168 of 1955-56 and case number 1169 of 1956-56, 55-56, the order was passed in favor of the defendants by the collector under the Bihar Land Reforms Act. And the state government also realized rent and granted rent receipt to the defendants to the knowledge of the plaintiff and also pro forma defendant. It was asserted that though the plaintiff claimed to have purchased the property in the year 1962, but before that year, the rent was already fixed in the name of the contesting defendants. But no appeal under section 8 of the Bihar Land Reforms Act was filed either by the pro forma defendant or by the plaintiffs. with this background, it was alleged that the plaintiff is not entitled to any relief, and the claim was hopelessly barred by virtue of Section 35 of Bihar Land Reforms Act. It was therefore the case that the plaintiff had applied for mutation in their name in the year 1962-63 and not for assessment of rent. And their case was registered as mutation case number 275 of 1962-63. And when the defendants were found in possession, it has also been asserted that the property was found in possession of the defendant even during Jharkhand operations, and the learned circle officer rejected the prayer for mutation on 28/8/63, and that order became final. And therefore it was pleaded that the plaintiff had waived their right, if any, and the plaint was imaginary and baseless. It was also alleged in the written statement that plaintiff could have brought the Karamchari in collusion who submitted the report in case number 345 of 7071 for fixation of rent. But upon objection made by the contesting defendants, the prayer for mutation was rejected by the order dated 29/1971 by the circle officer. Against which the plaintiff had filed appeal before the additional collector Palam, which was dismissed on 17/9/1975 in appeal case number Roman 15/74 of 71/72. The statement that with respect to the house standing on plot number 254, it was asserted that the same was constructed by the contesting defendants. It was asserted in paragraph 31 that Mausamar Janak Raj Kuwar was ousted from village in the year 1930. Until then, and she had not returned in the village. Therefore, the question of her possession over the suit land does not arise. चलिए आगे बढ़िए। नहीं ये एक और डिपेंडेंट D.04 इनका केस बताइए। पैरा नंबर the defendant number 4 has fully supported the case of the plaintiff. सपोर्ट किया है कि नहीं किया है प्लेंटिफ का केस? डिफेंडेंट नंबर 4 की बात कीजिए। उन्होंने तो सपोर्ट ही किया हुआ ना प्लेंटिफ को। ये सब तो कोई इशू ही नहीं है, जो इशू नहीं है उसके बारे में कुछ मत बात करिए। सेकेंड अपील में जितना है बस उससे रिलेटेड जो है बस a plea was also raised that the state of Bihar was not party in the proceedings. The defendant number 4 had supported the case of the plaintiff. Support में है आपके?
Support.
She denied to be a widow. Huh?
Yes.
Admittedly, this defendant is not a widow. Having religious temperament by nature cannot transfer. क्या कहानी बना दी आपने? The defendant number 4 had supported the case of the plaintiff by asserting that she was the ex-intermediary of the village and got the suit land in her exclusive share and possession on the basis of partition, suit number 24 of 1930, between the co-sharers of landlords the defendant was allotted the land by Takta number 4.
And the contesting defendant was party in partition suit number 24.
Just कहाँ लिखा है?
Para 2 में लॉर्डशिप
कहाँ लिखा है?
पढ़ लेते हैं। That the facts of this suit is that the defendant number 4 was the ex-intermediary of village Bhavandi, PS so district Palam, who bought the lands of the suit in her exclusive share and possession on the basis of partition suit number 24 of 1930 between the co-sharer land and the landlords in the court of deputy magistrate subject Palam, in which the defendant was the defendant number 1 of the opposite partition bearing number 11. The defendant number 4 of the suit is allotted. Defendant number 1 the party lordship.
उसमें defendant number 1.
उसमें defendant number 1.
हाँ certainly उनको allot हुआ पट्टा तो defendant number 1. Just a moment. Just a moment. The defendant number 4.
नहीं इसमें बोल रहे हैं पारा 2 में लॉर्डशिप in which this defendant was the party in
as defendant number 1.
This is my function.
बीच में कोई मतलब ही नहीं है सबमिशन। यही चीज प्लेंटिफ बोला, यही चीज आप बोल रहे हैं, कोई नया चीज बोल। She asserted that On the eve of vesting, the defendant number 4 had filed return under section 3B of Bihar Land Reforms Act 1950 and mentioned all the plots of the suit in the return, and the suit land was shown her as her Bakas land in her khas possession. She had also filed Form K for assessment of rent, and she was peacefully cultivating the land prior to transfer made in favor of the plaintiff. She asserted that she transferred the suit land in favor of the plaintiff by way of registered deed of sale dated 15/9/1962 for valuable consideration, and the plaintiff was put in possession. And she had also constructed one house in plot number 254, which was also ultimately transferred in favor of the plaintiff, in which the plaintiffs are residing. The statement of the contesting defendant number 1, 2, 3 that the pro forma defendant number 4 was ousted from the village since 1930 and that she had not returned to the village was emphatically denied. And it was further asserted that she always remained in village Bhavandu and got the cultivation work peacefully done without any interference from defendant number 1, 2, 3 and predecessor in interest. It was also asserted that the father of plaintiff number 2 and father-in-law of the plaintiff number 1, namely Sukhdev Ram, got a bogus sale deed executed in favor of the plaintiff. The defendant had transferred the lands in the suit to the plaintiff with the free consent and after receiving the consideration amount. It was denied that the defendant number 4 had settled down in village Dabra. It was also asserted that Babu Ram Naresh Singh and Babu Jaimangal Prasad Singh had no concern with the land of the defendant. It was asserted that now the defendant number 4 was a widow having religious temperament by nature, but the same cannot be said. But on that basis, it cannot be said that she could not transfer the property. Okay? Issues बताइए.
Para 8 of the amendment, we have 7 issues.
तो substantial question of law के लिए कौन सा issue important है?
Land rating of the plaintiff as the defendant perfected their right at the position of the
Adverse possession का तो कोई issue ही नहीं बने. एडवर्स पोजीशन का कौन सा इशू है जो आपके लिए रिलेवेंट है?
4 है, either suit land vehicle land of the place.
Okay.
Now, learned trial and
Altogether, 7 issues were framed by the learned trial court, and according to the appellant, the issue number 4 is relevant for the purposes of determining the substantial questions of law involved in this case. The issue number 4 was, is the suit land royalty land of the plaintiff? What is the finding?
the trial court and taken issue of 4, 5 and 7 put together, consider now. And and without any evidence of possession, well, that's one thing is not. That is, dispute is not. Who was in khas possession at the time of vesting of the zamindar? Immediately, the
That
suit
is not the
property,
dispute.
suit property was intermediary.
How are you claiming the property? What is your title over the property? How do you get the title over the property?
As per written statement, Lord, that it was the family property of the defendant's Lord and defendant also Lord, and she became widow, and his son also died Lord. So she left the village and she settled in village Gabra.
So you are a trespasser.
Therefore, the actual possession has become in the hands of the defendants. 1, 2, 3. Lord.
So you are a trespasser.
Yes, maybe.
So you do not have any
No.
derivative title from anybody.
The court below has also dealt with the evidence of defendant Lord. He said that ये मेरी दादी थी और जब दादी तो मौखिक रूप से हमको सुपूर्द करके दी, ऐसा लिखा है एविडेंस में आया है।
समझ?
तो एडमिटेडली अगर मान लीजिए कि हम एडवर्स पोजीशन में थे, मतलब ट्रेसपासर थे,
एडवर्स पोजेशन का
तो
सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं है। एडवर्स पोजेशन का फाइंडिंग आपके फेवर में है कि अगेंस्ट में?
एडवर्स पोजीशन अगेंस्ट में है।
अगेंस्ट। एडवर्स पोजेशन का फाइंडिंग नहीं है, इसलिए एडवर्स पोजेशन का कहानी बंद कर दीजिए।
Like this suit have to be proved by the plaintiff.
That's
The trial court had not dealt with any evidence which shows that at the time of vesting of the zamindari, the defendant 4 was in actual possession by cultivation. Although she filed a return, but and he said he claimed that she filed a
return was filed, the rent was assessed, and that particular it was assessed.
प्लेंटिफ के नाम से नंबर 4 के नाम से एसेस नहीं हुआ। She claimed that she filed a case for assessment rent, but in suit she had not filed case for. But the trial court only taken the weakness of the defendant and said that there was a katha in the name of
तख्ता प्रूव हुआ कि नहीं हुआ?
तख्ता
तख्ता प्रूव हुआ कि नहीं हुआ?
हाँ, तख्ता प्रूव हुआ, तख्ता था,
तख्ता था तो टाइटल
इवन तख्ता था, लेकिन whether she was in possession, if an intermediary interest Lord, after vesting Lord, all the lands vested to the state government Lord. And unless he at the time of vesting the ex-intermediary in khas possession, then only on payment of rent occupancy right of title can be accrued to the ex-proprietor. This was the provision of section 6 of the Bihar Land Forms Act. But she has not approved the case form, and even no single witness on behalf of the plaintiff has said that ex-intermediate Raj Kumar, or even the plaintiff was in possession, cultivating possession at the time of vesting law. And trial court also reported or observed law that all the DW has proved the case of defendant is the defendant are in cultivating position of the land.
So merely because the defendant is in cultivating possession of the land, he becomes a rayat. How does a person acquire the status of a rayat? Because defendant is not showing any right. Defendant is not showing any
Court below
title.
has not declared my title.
Court below has not declared your title.
Suit of the plaintiff.
If the court below has not declared your title, just a
Plaintiff
moment.
has to prove the case.
That's it. Court below has not declared the title of the defendant. The defendant claimed adverse possession against whom?
Against the defendant number 4 and the plaintiff.
And the plaintiff, that claim was denied. So
No,
the
neither
moment.
denied, not accepted.
What do you mean neither denied? What do you mean neither denied? There is a specific issue on adverse possession.
हाँ, तो उस पर जो है, not appellate court जो है.
अब ट्रायल कोर्ट से भी बाहर मत निकलिए, अभी
Trial court on the basis taken the witness of have not given any finding.
See, the moment you claim,
Neither issue was framed by as to whether the plaintiff or their predecessor in interest at the time of vesting was in possession within the meaning of section 6 and 2K of Bihar Land Reforms Act. Only possession, several case law have been discussed by this court law in earlier second appeal law. The trial court law had simply taken the witness of the defendant and decreed the suit law. And same way, one appellate could also dispute the appeal of the defendant wanted secret. Thereafter, second appeal has been filed. And second appeal has been filed that
the moment you claim adverse possession against the pro forma defendant and the plaintiff, you acknowledge that.
Yes, this is the case that to the knowledge of the ex-intermediary Jharkhand Kumar and the plaintiffs, they are in possession and on that possession basis.
So the title of the plaintiff and the defendant number 4 is not in dispute. What is in dispute is that they were not in possession.
Yes, before.
And
Yes.
the title follows possession.
Yes, title was there. After vesting, title has been extinguished.
How?
Because
And okay, after vesting,
after
just a moment.
interest.
After vesting, the title has been extinguished. So the property would have vested in the state,
Yes.
not in you.
No, but on
How
the
are
basis
you
of-
claiming title?
But on the basis of possession, the suo motu case has been started, and the state authority found the defendants in possession, and
No,
thereafter
there is no initiation of suo motu case.
Yeah, that case number has
No.
been.
Which case number? Suo motu case? We have seen the entire plaint and the written statement. Which case number is suo motu case? There is no suo motu case.
Yes.
केस नंबर बताइए suo motu केस
केस नंबर का दिया गया है इसमें एग्जिबिट D.01 जो है केस नंबर 1168 and 1169 55 56 जो है suo motu केस SM केस का क्या है suo motu SM केस
केस नंबर क्या होता है
केस नंबर 1168 and 1169 55 of 55 56 और इसके बाद आपका इसमें इंक्वायरी हुआ बिहार प्रोसीडिंग जो हुआ उसी में हुआ दैट प्रोविजन ऑफ बिहार अंडर सेक्शन 17 रूल 17 के मुताबिक रूल 7FG ऑफ द PLR एक्ट का रूल 7FG है इसके बाद बिहार हुआ आफ्टर वेस्टिंग उसमें इनका पोजीशन पाया गया। और उसके बाद रेंट रोल तैयार हुआ, एम रोल, AR केस नंबर 5 and 6 of 1960 और 62। You will give it E or E1 है।
Page 10 पे जजमेंट पास लीगल में ट्रायल को
आपको पोजीशन के बेसिस में आपका रेंट एसेस होता है। पोजीशन के बेसिस पे रेंट एसेस होता है, टाइटल थोड़ी डिसाइड होता है।
इसका रेंट जब हम एसेस हो गया तो हमको रेट मान लिया गया। हम पेमेंट कर रहे हैं, रेंट पेमेंट करते आ रहे हैं, उसका एक सी सीरीज है, रेंट सीरीज कंटीन्यूअस रेंट हम पे करते आ रहे हैं।
That's right.
My lord, the earlier second appeal by which the case was remanded, this is very relevant. I have already filed one copy of it, may have been not recorded, it's not.
आप अभी ट्रायल कोर्ट खत्म करिए। ट्रायल कोर्ट तो ट्रायल में तो रिमांड नहीं हुआ था ना, अपीलेट कोर्ट को रिमांड। हाँ, पहले ट्रायल
सेकंड
कोर्ट।
अपील में रिमांड हुआ था। सेकंड अपील में रिमांड हुआ था।
हाँ, ठीक है, हुआ होगा। पहले ये ट्रायल कोर्ट का फाइंडिंग पढ़िए, पैरा 9 पढ़िए। पैरा 9 पढ़िए तो
Between number 4, 5 and 7. These are the most important issues for the determination of issue. Hence, I first taken up them for discussion the support of the claim. Both parties have reduced number of oral and documentary evidence. Let us see how far they are acceptable. Defendant before the discussion in the other aspects of the case, following facts are admitted by the parties. It is also admitted for that Muhammad Raj Kumar was the owner and possession of the land till 1930. Till 1930. B. It is also admitted that the partition suit number 24 of 1930 was decided in respect of the property of the family of the defendants and pro forma defendant number 4, in which pro forma defendant Dhanat Rajkumar was the party. It is also admitted that the suit land along with other were allotted in the Katha of pro forma defendant 4, pro forma Dhanat Rajkumar, is that in that partition suit. Now, I admittedly defendant number 4, who is the gender of the plaintiff, had his title possession over the school land till 1930. The onus is on the defendant to establish the title and possession over the school land. Defendant number 13 has already admitted in paragraph 3 of the cross examination that the land in suit in their ancestral property and they have acquired it from Muhammad Janatra by oral gift. For further, they have said that this is the basis of his title by DT.02.12.2025 paragraph 3. कटरारी जमीन हमारा मनुष्य जायदाद है। मसोमा जनकराज कुमार ने जमीन मौखिक रूप से हमें देकर दूसरी गांव चली गई, यही मेरी हकीकत का आधार है। तो मौखिक रूप से जो है सो काका के चली गई कि आप लोग इसको रखिए।
मौखिक रूप से ट्रांसफर होता है, ओरल हिंदू लॉ में ओरल गिफ्ट होता है क्या?
कहा गया चली उसके बाद जो है वो क्लेम नहीं की,
देखिए उनका टाइटल डिस्प्यूट में नहीं है। ठीक है, और आपका स्पेसिफिक केस आपने बनाया है ओरल गिफ्ट, जिसके बारे में आपका कोई रिटन स्टेटमेंट में कोई जिक्र भी नहीं, एक वर्ड भी नहीं है ना।
लेकिन तो बोला कि डीड का रिटन गिफ्ट नहीं है, इसलिए ओरल गिफ्ट का बात कहा गया है।
आपके रिटन स्टेटमेंट में नहीं। आगे पढ़िए।
Thus, there is no doubt that Muhammad Kumar had his title and possession over the land. The claim of the defendant is that he acquired the right title and reverse possession. In support of this contest, he filed a number of the case laws reported in the year 1964 Court, Allahabad, penalty 55, necessity Supreme Court, case number Executive Council, Patna. In all these cases, law it is held that the plaintiff having failed to establish his possession within 12 years of the suit is barred by Article 152 of the Litigation Act. There is no dispute about the position left down in this case by adverse possession, means possession by person holding the land on his own behalf or on behalf of some other. The true owner having right to immediate possession, if any, he this adverse possession state is set running and if they contest to run for 12 years, then his title is extinguished and the person in possession becomes the owner. So in this case, the defendant had to establish his continuous and hostile possession against defendant more than 12 years from the date of the filing of the suit. On the point of possession, both parties have need evidences, oral and documentary. Now let us see how far they are acceptable. In the written statement, the defendant have alleged that possession from the year 1930 on this possession, number of witnesses examined who all said that the defendants are in coming peaceful possession from 1930. The year in which Nagaraj Dwar had left the village Bhavani. The defendant having failed to adduce a sheet of document from 1930 to 1955 for regarding their title and possession over the suit land. The defendant number 3, Ram Naresh Singh, admitted in his cross-examination that he had obtained this land from Muhammad Janakras Umar in 1930 on the basis of poor gift. No documentary evidence is filed in support of the gift. Oral have no document. The defendant have however alleged that at the time of vesting of Jamindari, they filed Jamindari return a fraud from showing these lands in their house possession, but in spite of that assertion, they have not filed the aforesaid paper in this court. On the other hand, the plaintiff had filed and proved the Jamindari return exhibit 4, showing that Muhammad Janakras Umar had shown plot number 2010 to 64, 65, 67, 68, and 93 in a khas possession. In column 13 of this Jamindari return indicates that disputed plot number 160, 20, 21, and 22 are in possession of the region. So far, these Raiti Khatas are concerned. The case of the plaintiff is that the pro forma dependent of 4 assert possession of the said lands when the Rayats had abandoned the village. The learned counsel for the defendant submitted that the plaintiff had failed to adduce any evidence on the point of abandonment. True, it is that the plaintiff had failed to adduce any evidence on the point of abandonment, but as the defendant number 3 has himself admitted in the examination that Muhammad Janakras Umar was in possession of the lands, there is no need for giving any evidence on this point. 1930 तक आप बोला है कि पोजीशन में थी, उसको तो अभी किया, उसके बाद तक नहीं किया, लेकिन उसी पर बोलता है कि इनको कोई जरूरत नहीं है करने का। There is no need for giving any evidence on this point. Moreover, the Rayats have not raised any objection. Rayat पार्टी भी नहीं है इसमें, इसको बोलते हैं एबोडोन किया, वो पार्टी भी नहीं, और तो बोलता है कि नो ऑब्जेक्शन हुआ। Hence,
रैयत तो वही है, डिफेंड नंबर 4
नहीं, डिफेंडर नंबर 4 तो एक्स इंटरमीडिएट थी, बोलता है कि वे रैयती प्लॉट था जो
एक्स इंटरमीडिएट का बकास की जमीन।
आकाश आया बोलते हैं कि जो रईती प्लॉट था जिसमें दिया है
उनका टाइटल तो डिस्प्यूट में नहीं है, फिर हम लोग क्या सोच रहे हैं?
उनका केस जो है कि जो रैयत था वो एबंडोन किया, एबंडोनमेंट का जो है कोई एविडेंस नहीं है। और नहीं कहते कि कोई उसमें ऑब्जेक्शन रैयत की ऑब्जेक्शन नहीं डाला। ऑब्जेक्शन तो तब डालता ना जब पार्टी रहता, कोई भी रैयत कब एबंडोन किया ये भी नहीं लिखा है कोई अपना प्लान में। तो पार्टी बनाते तब ना वो कहता कि हाँ हम एबंडोन किए, तब सवाल उठता कि ये ऑब्जेक्शन नहीं कर रहा है। Moreover, the Rayyat have not raised any objection. Hence, it can be safely held that the Musamma Democrat Kumar was in possession of the student at the time of history. The next document which is filed on behalf of the defendant is the assessment order and the rent receipts of the disputed land. The case of the defendant is that the suit land had been assessed through assessment case number 5 and 6 of 1961-62 and case number Sumoto, and Sumoto case number 1163 and 68 and 1169 of 1956 in favor of the defendant. The statement the government granted receipts to defendants within the knowledge of pro forma defendants and also the plaintiff. The plaintiff have applied for mutation for their names, which was after inquiry found false. The possession of the defendants was also found at the time of Bharat operation. The plaintiffs had preferred appeal before additional collector against the order of assessment rent of the defendant, but was to dismiss. Hence, as admittedly the defendants are paying rent since 1955. The plaintiffs or the pro forma defendant are whole if they have any right that was extinguished by adverse. So far the assessment order of the rent receipts are concerned, the learned counsel for the plaintiff committed that as the order was void ab initio, no need for setting aside from permission of the order in assessment case number 1168 and 1169 of 1956, exhibit D and D1. It is clear that land of block number 67 had only assessed. This is not only assessed, this is error of record. Several plots have been mentioned. It is clear that land of plot number 67 was only assessed through AR case number for suit plot number 210, 601, 114, 251, 623, 749, 51 are concerned. The rent of deed plot are fixed in the name of defendant on cumulative basis. When the case of the defendant is that he filed zamindari return and became form as that at the time of vesting, while the rent of only one plot 57 was assessed in 1955-56 on the basis of AR case. Why the other plots were not assessed? This is absolutely incorrect. All the plots have been mentioned in the order. On the basis of AR case, why the other plots were not assessed? Basis is fact highlighted so that no record of the aforesaid case were deposited in district record room of the Deputy Commissioner Kalam. It is indicative of the fact that the remarks were opened in the name of the defendant in collusion with unjust staff for which no case record was opened. This is this observation of the trial court law, the ill-founded law. The record, whether record was deposited in record room or not, law, that cannot be a basis for observing against the order passed by the circular officer. The defendants have failed to prove a sheet of paper regarding their possession of block number 254. Hence, in my opinion, the defendants have no documentary evidence of possession except the aforesaid rent receipt exhibit C3. On the point of possession and title, the plaintiff has defied the order and decree of partition suit number 24, 1930, marked exhibit 6 and 7. In this case, from this document, it is clear that the suit block allotted to the share of the partition suit, which was held by subject Lamu in suit under coming upon them. Exhibit 4 is a narrator about this document I have already discussed earlier. Hence, there is no need to discuss it. सिर्फ रेफर किया, डिस्कस नहीं किए. Exhibit 3 is the chowkidari receipt of the village Bhavandi showing that the plaintiffs are residents of village Bhavandi. One of the witness of the defendant DW4, Ram Maji, has also admitted that this fact. Hence, it can be safely held that plaintiff is residing in village Bhavandi on plot number 254. Exhibit 1 is a sale deed executed by the Nagaraj Kumar in favor of the plaintiffs. मतलब one thing that exhibit 1 is sale deed law. उस sale deed में जो है वो अपने जो स्टूडेंट है नागराज कुमार, वो लिखती है कि मैं बभंडी में से जब डबरा में आ गई बाहर आती, वो अपने एक्सकेप किया उसको डिस्कस नहीं किया है. Hence, it can be safely held that the plaintiff is getting village Bhavandi on October 21. Exhibit 1 is a survey executed with Nagaraj Kumar. There is no dispute about the exclusion of the survey. Hence, there is no necessity to any discussion on it. So far, the oral evidence are concerned. PW1, 3, 5 are the witness on the point of possession. They clearly say that the land under dispute is in possession of the land in dispute is in the possession of the plaintiff, and there is no cause to disbelieve their version in the aforesaid documentary evidence and admitted facts by the defendants. The defendants have also examined number of oral evidence in support of their possession, but except oral evidence, they have failed to prove their title on the basis of documentary evidence and the oral evidence of this witness cannot be accepted in light of the documentary. So there are several oral evidence of the defendants will prove the possession of the defendants at the time of vesting.
कौन सा oral evidence according to you is important? Which all मतलब? Everybody has supported your case. Plaintiff also.
Yes.
Plaintiff has also supported that you are in possession.
DW.
बताइए DW कौन से? क्योंकि substantial question of law में तो नहीं लिखा है कुछ.
नहीं.
बताइए कौन सा?
ट्रायल कोर्ट से मिला तो
DW का नंबर बताइए. किसका एविडेंस आप प्लेस करना चाहते हैं?
DW का बोल रहा है. DW का बोल रहा है कि उसको तो रेफरेंस नहीं किया.
How many witnesses are there?
उसमें ट्रायल कोर्ट हुआ है.
DW कितने हैं? How many?
DW 13 DT.02.12.
ये सब रेलेवेंट है पोजीशन पर.
सब पोजीशन सपोर्ट किया और उसमें भी ट्रायल को भी एक्सेप्ट किया है, जब किया है कि और DW as a prove the possession of the defendant, but no documentary evidence has been filed for possession. Documentary evidence.
So the point is that if a person has a title and if anybody else is in possession, title is not in dispute. If anybody else is in possession, then under such circumstances, and further the adverse possession is also rejected. Then, at best, what is the status of the person in possession? What is his status? Qua the actual title holder, he is a trespasser. You are a rank trespasser. Because adverse possession has not been declared in your favor, title has also not been declared in your favor, with which you are not aggrieved. Your entire thing is based on possession. Adverse possession has also not been decided in your favor. That has been rejected. So what will be your status? You just tell us that what is your status in law?
Whether I was trespasser or otherwise in possession, that has been, I was wrongly or rightly in possession at the time of vesting. And
what is the date of vesting? What is the date of vesting?
1955 में
1955 में. आपका रेंट रिसीट सबसे पहले कब कटा?
55 से.
दिखाइए. First rent receipt in your favor. First rent receipt का एग्जिबिट बताइए. सबसे पुराना कौन सा?
एयरपोर्ट की 1955 से.
पुराना कौन सा है? सबसे पुराना कब इशू हुआ है?
पुराना 55 का जो है वही है. इसमें सीरीज है.
डेट ऑफ इशुएंस क्या है?
देखना पड़ेगा रिकॉर्ड से. कॉपी मेरे पास नहीं है.
टीम में आए हुए. सॉरी पेज नंबर 10 एग्जिबिट टी एंड डी. एक प्लॉट एसेस की प्लॉट नंबर 667.
फैक्ट फाइंडिंग जो गलत है. DT1 का जो होता है जैसे एक प्लॉट का है गलत है. उसको दिखा जाए उसको मेरे सब प्लॉट आया.
अगर 1955 से आपका रेंट असेस्ड है, right? Then under such circumstances you acquire title. On what basis? Has there been any assessment with regard to your title or possession by the state authorities?
On basis of possession at the time of after vesting after vesting or the title of the ex-intermediary vest and still became the absolute owner of the property. And as per BR Act, Lord, if the state government found in possession of anybody, Lord, the state government may fix the rent in our favor, in his favor, Lord. And on that basis, Lord, the assessment case has been passed in favor of the defendants, Lord. And the AR case number 1168,
This is irrespective of the fact as to whatever return and etc. is filed by the original.
Return not relevant at the time of vesting, Lord.
Return has
Several case laws of the Honorable Supreme Court saying, Lord.
आप एक भी बताइए
दिखा दो. Several cases.
अच्छा, आप रिमांड का क्या बात बोल रहे थे कि एपेलेट अथॉरिटी में रिमांड किया था सेकंड अपील में, वो कौन सा ऑर्डर है?
उससे क्या है?
Which is that order?
I have earlier occasion, Lord. I have already had a photocopy of the judgment, Lord.
मेरे पास कॉपी
है.
पढ़िए, क्या पढ़ना चाहते हैं आपसे?
Para 2 से पढ़ते हैं. For the purpose of discussion of this appeal, it is not necessary to state the facts of details, as the same has been stated at the considered length of the court below. Sufficient it is to say that plaintiff respondents claim the land suit by reason of field of purchase executed in their favor by Jharkhand Rajkumar because in the court executed of 15/62, the giving was. Admittedly, Janak Rajkumar was a 10-year holder in respect of property in question, and upon vesting of the state in the state of Bihar, in terms of provision of Bihar national identity, she filed a return in Form K. Vesting of the identity in terms of provision of Bihar, she filed return in Form K. It is however admitted that no fair rent was assessed in her name pursuant to a personal return filed by her in terms of provision of Section 6 of the Bihar Land Court Act 1950. It is admitted that the defendants who claim the right that the interest in the property in question, although did not file any return in Form K for fair rent was assessed, allegedly they were found to be in khas possession of the property in question on the date of vesting of the state in the state of Bihar. By order dated 35/83, at the time of admission, the following substantial question law was formulated. In view of the fact that no fair rent was assessed in the name of Muhammad Chandra Duar, the member of the plaintiff respondent under Bihar Law Reforms Act, although a return was filed by her in Form K, whether in law, in the absence of any evidence, can be said that the land in question was deemed to have been settled with her as a rayat after vesting of her intermediary estate in the state of Bihar. The NK Prasad, the London Council, appealing on behalf of the plant, when confronted with the provisions contained in the Section 6 of the Bihar Land Court Act 1950, very fairly considered that if the outgoing proprietary was in khas possession of the land in question of the date of vesting, he would become a rayat having been occupancy rayat under the state of Bihar. Irrespective of the fact as to whether the fair land has been assessed in his name or not, in as much as the matter relating to the fixation of fair land and payment thereof is a question between the state of Bihar and the outgoing tenure holder. Mr. Prasad, however, submitted that another substantial question of law arises in this case, which would appear on the basis of judgment of the learned court below, which is as follows. Whether the learned courts below committed an error in law in not giving a finding that Janak Rajkumar was in khas possession of the property in question on the basis of the date of coming into force of the Bihar Land Court Act. In this view of the matter, the only question that arises for consideration is as to whether the plaintiffs have been able to prove title by establishing that their vendor was in khas possession of the property in the suit on the date of vesting of the estate in the state of Bihar under Bihar Land Codes Act or not. In terms of the provision of Section 6 of the Bihar Land Codes Act and in view of the various decisions of the Supreme Court in this court, namely Suraj Nath Ahir versus Prithvinath Singh 1963 1, Gurcharan Singh versus Kamla Singh 1977 and Badri Singh and others, Mansuri Hasan Khan and others 1977 division 642. There is no escape from coming to the conclusion that in order to acquire a righty title, having been occupancy right under the state of Bihar, in terms of the provisions of Section 6 of the Bihar Land Codes Act, a tenure holder must be in khas possession of the property in question on the date of the vesting within the meaning of Section 2K of the Bihar Land Codes Act so as to become a resident having occupancy right under the state of Bihar as contemplated in Section 6 thereof. Unfortunately, this aspect of the matter has not been considered by the learned court below. The learned trial court also did not formulate any substantial issue in these regards, but in paragraph 8 of its judgment, it formulated many issues. The main issue being issue number 4 is as follows: is the suit land rightly land of the plaintiff? In paragraph 11A of the judgment, the learned trial court came to following findings. On the other hand, the plaintiff had filed and proved in the return in the court saying that Muhammad Janakar Kumar had shot block number 210, 254, 601, 665, 667, 668, 293 in a class position. In column 13 of this Jamindar return, she indicated that disputed khata number is not in possession of the Rayya. So far these righty khatas are concerned, the case of the plaintiff is that so far dependent on court came in possession of the lands when the Rayyas had abandoned the village. The learned counsel for the defendant submitted that the plaintiff had failed to adduce any evidence on the point of abandonment. Proof: it is the plaintiff had failed. It is that plaintiff had failed to adduce any evidence on the point of abandonment. But as the defendant number 3 had himself admitted in the exemption that Muhammad was in possession of the lands, there is no need for giving any evidence on this point. Moreover, the Rayyas have not raised any objection. Hence, it can be safely held that Muhammad Janakar Kumar was in possession of the suit land at the time of vesting. The learned lower appellate court unfortunately also did not address itself on this vital question. It formulated 3 questions for its consideration in paragraph 11 of its statement. Question number 1 and 3 thereof are as follows: whether plaintiffs have right, title, interest, and possession over the suit land or not are entitled to the relief claimed by them. Whether the defendants have been in possession of the suit lands all along since 1930 in the manner alleged by them, if so, to what consequence. These 2 points were discussed by the learned lower appellate court for consideration together. In paragraph 12 of the judgment, they considered the case of plaintiff that acquired title to the property by reason of a partition in partition suit number 24 of 1930. In paragraph 13, 14, 15 judgment, the learned lower appellate court discussed the case of the defendant and the negative theory of title and possession. In paragraph 16 of the judgment, the learned lower appellate court discussed the sum of the document, which according to him, were not relevant for the purpose of this issue. However, as indicated here before, without in any manner discuss the evidence adduced by plaintiffs, whether oral or documentary, the learned lower appellate court come to the conclusion that from evidence it is appears true that Janakar Janakaraj was owner of disputed land and was in competition even the day of this. True, it is that unless no appellate court rejected the claim of defendant, but in my opinion, the same does not clinch the issue. Even if the defendant had no title or possession in respect of the property in question, it was incumbent upon the plaintiff to show that the former defendant number 4, Janakaraj was in khas possession of the property in question on the date of vesting of the zamindari. Say and accept by showing that Janakaraj was in khas possession of the property on the date of vesting in terms of section 6 of the Jharkhand Land Forms Act. She do not have claim title in respect of the property in question. The learned court below could have proceed on the basis that plaintiffs are entitled to a decree for eviction of the defendant on the basis of their possessory title, but proceeds to grant a decree on the basis that the Kumar becomes a rayat having occupancy right in terms of section 6 of the Jharkhand Land Forms Act. From above discussion made in the report, it is absolutely clear that the trial court found that the property in question here at one point of time in possession of the rayas, who evidently were inducted therein and allegedly abandoned the dispute land. However, from judgment of the trial court itself, it is evident that plaintiffs have not been able to prove the fact of abandonment. Therefore, the question which arises for consideration was as to whether and if so when Janakaraj came in possession of the property.
You just tell us that even if your possession is found, what will be your status?
After assessment of rent, the defendants become rayat.
By
After
virtue of
getting
assessment of
after
rent.
getting of zamindari, the ex-landlord is not applied for assessment of rent or even applied, no assessment of rent was made in favor. They have got no title can be approved to them the fixation of rent, and therefore the plaintiff claiming purchase had no right and title on that basis. One main question is whether the ex-intermediary at the time of vesting of zamindari was in khas possession or not. Within the meaning of section 6 and section 2K of land enforcement. No such. Well, after demand, the court below, what appellate court, Paranai, formulate 2 points. At Paranai. The point for
इसमें एक हम लोग डिसाइड किए थे definition नौकराना लैंड नौकराना सेक्शन 6 ऑफ लैंड कॉन्सेप्ट स्पेलिंग उसका होगा उसमें ये मिस्टर शर्मा एप्लीकेंट चक्रान नौकराना या चक्रान NEQ, NEU, KARAN,
Mr. Sir, first
And-
appeal number 188 of
है ना?
2018.
सही yes.
Akhil
188 of
2008, according to us, Akhil Mandal,
your नाम थोड़ी याद.
first appeal है.
फर्स्ट अपील में डिसाइड किए थे.
हाँ, 188 of 2018. उनसे हम मांगे तीनों बनाना सम्मिलित कोई
आप लाए हैं क्या?
हाँ, मेरे पास इनको दे संजीत सर.
इसमें SLP नहीं फाइल हुआ पता करिए. फर्स्ट अपील 188 of 2018. आपका ये कहना है कि पोजीशन अगर आपका है तो वेस्टिंग में दिस लेडी कुड नॉट हैव बीन डिक्लेयर्ड एज अ राइट. यही है आपका कहना.
उनका पोजीशन नहीं था और क्लेम भी नहीं.
लेकिन रिटर्न वगैरह तो फाइल की थी ना.
रिटर्न फाइल की थी.
रिटर्न में असेसमेंट हुआ था कि नहीं हुआ था?
नहीं हुआ था. इसमें तो है आया फेवरेट डिसीजन देता है इसको फाइल.
नहीं, रिटर्न में असेसमेंट हुआ था कि नहीं हुआ? क्यों हुआ था ना, आपने चैलेंज नहीं किया था. अच्छा,
नहीं।
उन्होंने नहीं चैलेंज किया था आपका रेंट असेसमेंट.
ये नहीं
हाँ,
था.
इनका रेट से तो हम लोग चैलेंज नहीं.
ये चैलेंज.
इनका रेंट जो फिक्स हुआ था वो आपने नहीं चैलेंज किया था.
हमारा जो एग्जिबिट 4 है रिटर्न फाइल वो उसको यहाँ चैलेंज नहीं.
इसमें सुप्रीम कोर्ट कहता है कि इवन रिटर्न हैव बीन फाइल्ड बाय एक्सप्लेन दैट इज नॉट द एविडेंस ऑफ खास पोजीशन. खास पोजीशन is the ex-intermediary if has himself cultivating the land, either himself through survey or by any manner, then only khas possession can be approved, deemed or right.
ये तो हुआ कि उनका राइट नहीं हुआ, और आपका राइट कैसे हुआ?
हम तो पोजीशन में थे. हमारा पोजीशन हमारा कल्टिवेटिंग पोजीशन पाया गया.
एक सेकेंड. Irrespective of the fact a person is an intermediary or not, but any third party found in possession will be entitled to be recognized as a right.
Yes.
इस पर आप हमको जजमेंट दें. कहाँ है वो जजमेंट? Because I have my doubt.
As per
कौन सा जजमेंट है कि जो भी आदमी पोजेशन में था, whosoever was in possession on the date of vesting acquires the status of a right.
इसका रूलिंग हम देंगे. लेकिन अभी जो है ना सुप्रीम कोर्ट का जो कंटिन्यूअस जो ओपिनियन रहा है कि
कौन सा है?
सिंपली फाइलिंग रिटर्न by
You see,
landlord
the point is
is not
filing return.
yet not challenged. Nobody has challenged. Neither state government has challenged. State government has ought to have been made party in this case.
That's
I have taken plea in that written statement, and he has not admittedly not challenged my assessment order.
आपका रेंट असेसमेंट तो म्यूटेशन प्रोसीडिंग में हुआ था ना?
म्यूटेशन
नहीं,
प्रोसीडिंग.
हाँ.
Sumoto विधारक proceeding हुआ था. After vesting the collector has power to inquire the matter as to who is in possession, as per section 7, in that proceeding, my possession was found, and on that basis, rent has been assessed in my defendants. That has never been challenged.
So कोई ऑर्डर भी एग्जीक्यूट नहीं हुआ.
DT1,
तो एडमिटेड फैक्ट.
E1,
इसमें तो कोई डिस्प्यूट ही नहीं है.
my
विचारक
submission is.
प्रोसीडिंग हुआ था.
My submission is that in the remand order judgment also, irrespective of the fact of whether defendant is entitled or not, but plaintiff have to prove the case on the basis that defendant number 4 was in khas possession and thereafter she approved the occupancy right. Then only she can exclude the sale deed.
Plaintiff did not pray for
Yeah.
declaration of title. No.
No, anti-paid for declaration of rarity title also.
Anti play for right title and possession.
No, plaintiff has not prayed for declaration of right.
Thus be adjudicated and declared that the lands in suit fully described in schedule at the root of the plaintiff in Village Babandi, district Palamu, are the lands owned and possessed by the plaintiff.
And the title and possession has not been affected by
Affected by
any order passed by the revenue
authority.
authorities.
So possession and
आपके नाम से म्यूटेशन हुआ था कभी?
नहीं, मेरे नाम से म्यूटेशन नहीं हुआ, मेरे नाम से म्यूटेशन नहीं हुआ,
खाली रिटर्न फाइल कर।
हाँ रिटर्न फाइल किया, हमारा सेल डीड है। ये दावा कर रहे हैं ओरल गिफ्ट के आधार पर।
नहीं, ओरल गिफ्ट का तो कोई केस ही
नहीं बन रहा है।
वो भले कुछ भी कर रहे हो, but there is no case of oral gift, so we will not acknowledge that.
But the DW3 laws say
You just no. Let us just
half possession at the time.
ये वाला ना ऑर्डर होगा हमारे इसमें थोड़ा देख के निकालते हैं। मेरे फर्स्ट अपील वाला ऑर्डर
The lower appellate court after demand
और जरा देखिए इसको एसएलपी में चैलेंज हुआ है ये कौन सा रिकॉर्ड प्लेस कर रहे हैं 76 टू
Supreme Court.
1963 Supreme Court.
Para 21 and 22.
पढ़िए
Section 6 does not stop with merely saving lands in khas possession of the intermediary.
नहीं 21 पे कुछ और है 63 सुप्रीम कोर्ट 454
454
हाँ पैरा 21 रिलायंस was placed पैरा 20 से पढ़िए on the date of vesting
On the date of vesting,
Hmm.
the appellants were not in possession, and the mortgage had been giving in reality. Possession of the appellants was not as mortgage. It may be as trespasser or in any other capacity. The land in suit, therefore, did not come within clause C of Section 6 of the Act, as it stood where the High Court delivered the judgment. 21. The reliance was placed by High Court on the case reported in 1958 Patna, 89, for construction put out expression khas possession to include subsisting title to possession as well, and therefore, for holding that any proprietor with the right to get khas possession of the land is not barred by any provision of law, will have a right to recover possession, and that state of the art shall treat him as a real with a comprehensive right and not as trespassing. We did not agree with this view. When the definition of khas possession means the possession of the proprietor or tenure holder, either by cultivating such land himself with his own stock, or by his own survey, or by hired labor, or with hired stock. The mere fact that proprietor had a substitute title to possession over certain land on the date of vesting, he could not make that land under his calculation. It is clear, therefore, that the land in suit cannot be deemed to be settled with the respondent by the state in accordance with the provision of section 6 of the Act. In the absence of any such settlement, no right over the land in suit remain in the respondent after date of vesting. All their rights are vested in the state by virtue of subsection 1 of section 3 of the Act.
आगे बढ़िए 23 नंबर
We are therefore of the opinion that respondent lost their right to recover possession from the appellants even if they were trespassers on their estate vesting in the state by virtue of section 3 and 4 of the Act, and that therefore thereafter they had no substituting right to recover possession from the appellants. The right to possession now vests in the state. The respondents being no more entitled to recover possession of the land in suit, the decree of the High Court has to be set aside. We accordingly allow the appeal set aside the decree of the court below and restore the decree of the trial court, though for reasons other than those given by the court in its judgment. In the circumstances of the case, we order the party to bear their own cost. So, past possession I have to prove by its landlord, and where filing a return, it is not sufficient.
just a moment. What is the other judgment? 1976.
Page 5. 19.
Guru Charan Singh.
76
पढ़िए पैरा नंबर पढ़िए
Para number 21 and 22.
पैरा नंबर पेज नंबर 166 पढ़िए just a minute.
Section 6 does not stop you merely saving land and past possession of intermediary.
नहीं पेज नंबर 1 ये लास्ट सेकंड लास्ट पैराग्राफ पढ़िए
Page 7.
Although we need not elaborately study the implication of this provision, 7H का है.
But reason I have 21 there. 22.
अच्छा आप इसमें क्या प्लेस करते हैं बताइए.
21 and 22.
Twenty-one point.
Section 6 does not show is merely saving land in past possession of intermediary erstwhile proprietor, but proceeds to include certain lands of the standing or temporary lease or mortgage with others. As earlier indicated, these are private lands as known to the Bihar Indonesia, private lands as known to the Sudanese Indonesia, land of standing with the mortgage pending redemption, and lands which are actually being cultivated by the proprietor himself. Ordinarily, what is outstanding to the lessee and the mortgagee will not fall within half police. The legislature, however, thought that while the permanent dealer's rights should be protected, and therefore, renters and under-renters should have rights directly under the state, eliminating the private property. The zamindar or proprietor also should be allowed to hold under the state on payment of fair rent such lands as have been in his cultivatory position, and other lands which were really enjoyed as private or village land or mortgage or possession by him with his in view. Section 6.1 is large scope by including special categories. The word include is generally used in interpretation clause in order to enlarge the meaning of the words or phrase occurring in the body of the statute. It is obvious that section 6.1 uses the word including to permit enlargement of meaning of khas possession for limited purpose of that section. Emphasizing thereby that, but for such enlargement, the expression khas possession includes lands of standing even with temporary lease. It is perfectly clear, therefore, that khas possession has been used in the stricter sense of the actual possession, and to the small extent it had to be enlarged for giving relief to proprietor in respect of private, privilege, and mortgage land. Inclusive expression had to be explained. Khas possession is actual possession, that is a foothold on the land and actual injury. A possession, in fact, a standing upon it, an occupation of it, as a regional administrative act done. Constructive possession or possession in law is what is covered by subsection clause of section 1 even so. It is impossible to conceive, although the Misra wanted us to accept that possession is so wide and include a mere right to possess. When the actual dominion over the property is held by one in hostility to the former, the possession correctly understood means effective physical control or occupation. The word possession is sometimes used inaccurately as synonymous with the right to possess. What the phrase second edition under page 41 in the dictionary of English law and possession is deemed as following possession: the visible possibility of exercising physical control over the thing, coupled with intention of doing so, either against all the world or against all the world except certain persons. There are therefore three requisites of possession. First, there must be actual or potential physical control. Secondly, physical control is not possession unless accompanied by intention. Hence, if a thing is put into the hand of a sleeping person, he has no possession of it. Thirdly, the possibility and intention must be visible or evidenced by external signs. For if the thing shows no signs of being under the control of anyone, it is not possession. In the end of all, however, the meaning of possession must be depend on the context in which it may be. In certain situations, possession may cover right to possess. It is thus clear that an Anglo-American Anglo-American jurisprudence also possession of actual possession and in a limited set of cases may include constructive possession. But when there is a bare right to possess benefit of any dominion or factum of control, it will be strange legal travesty to assert that an owner is in possession merely because he has a right to possess when a rival in the fifth of owner's position is actually holding dominion and control over land adversely, openly, and continuously. Admittedly, in their case, possession of the plaintiff had ceased totally at least 2 years before the vesting under Section 4 took place. This situation excludes half possession. We have the uniform authority of this court hold that the possession of a trespasser by no stretch of imagination can be deemed to be half possession or even constructive possession of the owner. In Kulinath Ahir, 1960 Supreme Court, this court considered the definition of half possession in the Act in the context of Section 6 and after adverting to Brinandan Singh Jamuna Prasad in 1950 Patna, on which Sri Mishra placed massive reliance on that. Reliance was placed by the High Court on the basis reported Brinandan case Jamuna Prasad for the instruction put on expression half possession to include substituting title of possession as well, and therefore holding that any proprietor who the right to get half possession of land is not barred by the possession of law will have a right to recover possession. So that state of Jharkhand him as a real equality right and not as a trespasser. We do not agree with this view. When definition of half possession means the possession of a proprietor or tenure either by cultivating such land himself with his own stock, or by own survey, or by hired labor, or with hired stock. The mere fact that proprietor has a subsisting title in possession over a certain land on the date of vesting would not make that land under half possession. The attempt to distinguish this decision on the score that the observation is omitted does not appeal to us, and rule laid down there in the conformity with the principle we have earlier expounded. The law has been indubitably laid down in the Ram Gas in 1965, where the position of 5 judges of this was discussed half possession in Section 2K and the scope of Section 6 of the Act. The same equivalent case are referred to Sukhdev Das and Kasi Prasad was placed before the learned judge and overruling this case. Ayengar is speaking for about stated the law in these unmincing words. Mr. Sadhu Prasad, however, relied on certain observations in the judgment of the full bench of the Patna High Court in Sukhdev Das, Kasi Prasad in the full bench, where the learned judge appeared to concede the possession even of a trespasser who had not accepted title by a non-person for time refugee under Indian Limitation Act, half possession of the true owner. We consider that this question of the right to possession is half possession is not justified by principle of authority. Besides, this is also inconsistent with the reasoning of the full bench, of which constructive possession is treated as being the concept of possession. The possession of contesting defendant in this present case was in their own right and adverse to the plaintiff even on case in which the clans themselves came to the court. In this context, the plea made by the plaintiff relevant to the character of the possession of the contesting defendant assumed crucial importance, for if they were admittedly trespassers, then they could not be said to be hold the property on behalf of mortgagors, and the entire basis of the argument as to the property being in the half possession of the plaintiff would disappear. It was on the basis of their possession being wrongful that a claim was made against them for misprofit, and it was on the footing of their being trespassers that their suit and possession sought to be recovered from them. In these circumstances, we consider that it is not possible for the class to contend that these tenants where the possession of the property on behalf of mortgagor and the character of their rights being derived from mortgagor. The court rejected the theory that possession of trespasser was that of the owner. Other decisions of the Patna High Court and this court were referred to that bar, but the possession having been made unmistakable by two cases just mentioned, we do not wish to burden this debate in case law any further. Conclusion we therefore draw is that of the facts found in this fact honor the plaintiff has no past possession of the woodland and cannot sue section use section 6 as a rescue the title was lost when section 4 was notified as applicable to the suit landslide section 3 1956 without title he could not maintain the action for recovery of possession, but that is not the case of matter. He is a certain intact in the means to proceed from the defendant firstly until the date of vesting, January 1 and is another matter. So, in this, it will also court observe and held that khas possession means possession by physical action by cultivating the land. And other judgments are also same points.
There is one more judgment.
Yes.
Baleshwar Tiwari. आपने जब रेंट असेस किया था तो इनको सुना था क्या? At the time of assessment of your rent, were they also heard?
He was not there.
हमको नहीं सुना गया था ना नोटिस हुआ था
उनसे नहीं था after vesting he had no more right unless he claimed possession at the time of Jharkhand. He not kept.
He had filed the lady had filed a return.
Return file किए थे लेकिन
आप एक जजमेंट दे रहे थे कि रिटर्न फाइल करने का कोई रेलेवेंस नहीं।
क्लेम नहीं किए, रेंट असेसमेंट का कोई क्लेम नहीं किए।
रिटर्न फाइल करके तो अपना क्लेम किए थे ना, तभी ना रेंट असेसमेंट होगा जब फिर रिटर्न नहीं फाइल होता है।
उसका अलग क्लेम होता है। तो एज एक्सप्रोप्राइटर ही वाज ए ऑब्लिगेशन टू फाइल रिटर्न। बालेश्वर para 9 to 12. This was regulated by bench of the two judges of Ramesh Kumar Sharma,
इसको कल सुनिए, फर्दर कल सुनिए। आपको क्या कहना है?
कल हम इसका जवाब देने की कंप्लीट कर रहे हैं।
आपका नहीं, आपका मोटा मोटी तो सोचोगे ना क्या कहना है?
मोटा मोटी नोट से मैकेनिक्स इशू फ्रेम बट डेफिनेट ट्राई करूंगा।
सेकंड हाफ में निकल
नोट से मैकेनिक्स इशू
12 AM का भी।
नहीं, आपके हिसाब से टाइम नहीं हो सकता सर, कोर्ट का टाइम 10:30 बजे।
Page number 5 Lord, see issue frame by Learning Tricourt Lord, see. Is the suit like directly land of the plaintiff as the defendant perpetrated their right title interest and possession over the suit land.
रैयती लैंड आपका डिक्लेयर किया है.
हाँ, Lord, second thing is Lord, he
We'll see that. But you were not in possession.
I am the possession. The defendant DW3 himself admitted that I am the possession of the land. Lord, may kindly see the judgment passed by the learned trial court. अब let me हमको बोलने दीजिए. आप बोल दीजिए. हमको ही बोलिए क्या? अब हमको बोलने दीजिए. आपको बोल दीजिए सर. हमको ही बोलने दीजिए.
We
Lord,
will
may
see.
kindly.
We will see the evidences.
Yes. Lord, may page number 8. Lord, may kindly see. I am reading relevant. The defendant had failed to adduce a sheet of document from 1930 to 95 regarding their title and possession over the suit land. The defendant number 3, Ramnath Singh, admitted in cross-examination that he obtained the land from the Musma Janak Raj Kuwar in the year 1930 on the basis of oral. This is not relevant. I am coming.
Oral gift claim कर.
हाँ, oral. Yes, page 9. Lord. Page 9. Lord. As the defendant number 3, who is the defendant number 3, DW13, has himself admitted in his admission that Musmat Kumar was in possession of these land, there is no need for giving any evidence on this point.
She was in possession till what date? She was in possession in 1930.
No.
Is there any finding that she was in possession on the date of vesting?
No, there is no. But the DW.
इसीलिए तो है इतना substantial
इसी
question.
तो बना है. सही बात. इसी तो बनता है.
कल गवाही पढ़िएगा. कौन सा गवाही बोल रहा है कि पोजीशन आपका बिना पढ़े ही सुबह 10:30 बजे से बहस कर. सारा तो उसी पर है. दूसरी बात आप बताइए, अगर इनका पोजीशन पाया जाता है ऑन द डेट ऑफ वेस्टिंग, दिस लेडी डिपेंडेंट नंबर 4 had any rayati right?
Yes. Lordship, the rent was assessed only plot number 667, which is not the suit land, Lordship.
इनका रेंट से प्लॉट नंबर 667 पर हुआ है सर.
Yes.
We'll see that. We will see that. We'll see that. The arguments have remained inconclusive. Post this case for further arguments tomorrow at 10:30. ये वाला जो है ना, इसका फोटोकॉपी कराइए और इसमें रखिए, इनको वापस कर दीजिए. इसमें तो हम कुछ डिसाइड किए थे. फर्स्ट अपील 188 में.
Nokrana land, so far as Nokrana land is concerned, CLT Act will not apply.
नहीं, ये वाला जजमेंट भी कंसीडर किए थे, जो ये साइड कर रहे हैं ना.
2004 बोल में लल्लू सिंह केस.
नहीं 76 का.
27
वो भी कंसीडर.
Lordship, may I pray, Lord? The evidence का मेरे पास कॉपी नहीं है, अगर फोटो कॉपी
नहीं मिल सकता ना. आप आराम से बैठ के पढ़िए, सेकंड हाफ पूरा टाइम आपके पास.
इनके पास तो कॉपी है, दे दे फोटो करवा. अभी तो आप देख रहे थे.
सर ऐसा लुका छिपी खेलने से क्या होगा? आपका केस एडजर्न हो जाएगा. अगर है तो दे दीजिए उनको.
फोटो करवा लेते हैं सर. जीता के आपका नहीं है.
जिसका भी है दे दीजिए ना, क्योंकि वो जो आपके पास है वही तो आप रिलाई कर रहे होंगे.
हम उसी को दे देंगे. हम फोटो करा के दे देंगे. हम सब दे देंगे जी. हाँ तुरंत
पास हो जाएगा. वो हमको चाहिए फोटोकॉपी उसका. करवा रहे हैं. करवा के आपको वापस कर देंगे. सेकंड आपको ले लीजिए. कॉल कर दीजिए. एक पास हो गया.
Parcel of case from supplementary list item 4, second appeal 194 of 2006.
The case is otherwise ready.
Yes, I think HCR.
Which IA you don't want to press?
One 4047.
One 4047 is stay petition.
Lordship.
You don't want to press.
Lordship.
You don't want to press this other.
Don't watch. Uncle, I which one? I wanted, I heard
Okay,
other.
dismiss as not pressed.
4836
Okay.
of 24.
Learned counsel for the appellant submits that he does not want to press IA number 4836 of 2024, whereby a prayer was made to impede the subsequent purchaser of the said property. Any objection? The learned counsel for the respondents has no objection to the prayer. Accordingly, IA number 4836 of 2024 is dismissed as not pressed. Okay.
So far as the other IAs are concerned, there is one under order 4127.
Yes.
If you can file my reply by Friday. Let this
There
matter
is
come.
by additional evidence also.
14046. For this lordship, they can.
क्या है additional evidence है?
Lordship, the case basis upon one exhibit 3 lordship. I'm just stepping the second lordship. Exhibit 3. Exhibit 3 lordship is a permission under section 46, whereby the original defendant number 3 got permission to sell the land in favor of the tenant. And when the search was made, lordship, although it is a certified call, but when RTI was given and the entire search was made, it is said that no such record is available in the record. For that purpose, lordship, under RTI we have obtained this, and that we wanted to produce before the Honorable Court, because the entire thing hinges upon the same exhibit 3.
Why did you make the search at appropriate point of time?
Because lordship, there was some
Was your case that it is a forged and fabricated document?
No, that was not this.
तो फिर ये क्या है additional evidence का क्या relevance है?
ठीक है, sir, उसको. Since that was obtained by the client, I thought that it may be useful for you.
वैसा कोई allegation ही नहीं.
Allegation नहीं है, उसमें नहीं. But
Permission was given
WSP
is not in
allegation
dispute, तो
नहीं.
इसका अभी आइए reject करने लायक.
उसको इधर-
Second appeal में है ना, first appeal में नहीं है कि हमको आइए consider
नहीं,
करना होगा at the
बिल्कुल,
time of hearing. We'll reject it right now. बताइए. Substantial question of law claim.
Free.
ठीक है, अब ये आइए का क्या ही होगा? कुछ नहीं होगा ऐसा आइए का.
इसको जरूर भी रहने दिया जाए, let them file.
कैसे नहीं? जरूरत ही नहीं है. ऐसे यहाँ पे टाइम देने के लिए थोड़ी है. You just satisfy me on this.
There is no pleading I have checked in the WS regarding permission that it was obtained fraudulently or that permission which is
रिकॉर्ड नहीं मिल रहा है तो
permission is
जब
exhibit
आपको
3.
वहाँ पे एग्जिबिट कर दिए हैं, मार्क हो
नहीं
गया
नहीं
exhibit,
नहीं, अभी हम just I was just checking.
तो बस
इसको withdraw करो.
विड्रॉ करना.
हाँ, better.
आइए नंबर 14046 of 25. The learned counsel for the appellant
146.
does not
14046.
want to press this interlocutory application seeking to adduce additional evidence. The learned counsel for the respondent has no objection to the payment. Accordingly, IA number 14046 of 25 is dismissed as not pressed. हो गया? अब क्या उनसे बचा?
हाँ,
Stay.
मुझे लगता है 14047. It is for a stay of
आप
case.
बताइए क्या चल रहा है?
Just we were speaking and I spoke before in front of him to the learned counsel who was conducting the execution case. He said he is not taking any steps. Let this case come on Monday. We'll assist your lordship for final disposal. He's not taking
I will record your submission that they are not, you are not taking any
Till
steps.
Monday we are not taking any steps. Today was the date fixed in the execution case. We are not taking any steps.
This is for specific performance.
No, for recovery of possession, declaration of title, recovery of possession.
And for that lordship, for that purpose, lordship, the rate has been assigned to the sister. Once the report comes, lordship, it will be very difficult.
You
for
see, we shall fix a date, but please, I will
Since
stay
lordship
the
already-
execution.
stay was there,
We are not
lordship.
taking any steps.
I will stay the execution proceedings. If you are not taking
And we
steps,
have
now,
also
there has
filed
to be a positive order of the court.
BG is also.
I am otherwise-
What about the BG?
Ah, yes, lordship. Please, lordship, may kindly come to
I am otherwise ready.
Page
On merits
23,
also,
page
Lordship
20
may-
page 23 of the IE Lordship. That is the order sheet of the court's order sheet is there. 16/9/25.
Yes.
Both the parties are in attendance. Judgment letter filed bank guarantee 9/9/25.
Okay,
Copy of this one has been served to the degree holders.
that's
It is kept on record. And I have also the copy of this. It is extended till July 2026.
IE number 14047 of 25. This petition has been filed seeking stay of execution proceedings of execution case number 5 of 2006, renumbered as execution case number 126 of 2023, again renumbered as execution case number 29 of 2024. Which is pending before the court of
Court of Lordship. Sri Sarthak Sharma.
designation letter.
Not sure, I'm just checking. Additional Civil Judge Junior Division Ranchi.
Additional Civil Judge Junior Division Ranchi. The learned counsel has submitted that the case is otherwise ready for final hearing. The substantial question of law has already been framed in the present case. By order dated
perhaps 3/8/2007.
by order dated 3/8.
2007 Lordship, order number 6.
देखें ना क्या है, हमको कितना टाइम लगेगा.
By Pleader Commissioner वाला.
अच्छा. By order dated 3/8/2007. He submits that writ for delivery of possession has already been issued.
It has been sent for solicitor's report.
It is not.
No, that is the order sheet.
Not been issued.
He has submitted that report has been called for from the solicitor on the point
Date has
of
been fixed today for Lordship.
on the point of issuance of writ for delivery of possession. He submits that today is the date in
Fixed
the
for the solicitor's report.
fixed for the report of the solicitor. The learned counsel for the respondent has submitted that the writ for delivery of possession अभी तो नहीं, you do not know issue हुआ कि नहीं.
It is not made. अभी
The
तो
writ for,
क्या-
just a moment, the writ for delivery of possession has not yet been issued and he is otherwise ready for final hearing of this case. And on instructions, he submits that the respondents would not take any
Respondent
step.
number 1.
Respondent number 1 shall not take any step in the for furtherance of the execution proceedings
Till the next date.
till the next date of hearing. मंडे को हम लोग कुछ रखे हैं क्या समीर जी? मंडे को कुछ रखे हैं क्या?
Shota, so the question of law is also already been answered.
Like
आपको दे दें.
हाँ.
Para 3, 4 copies.
answered in your favor.
One more point is there, Lordship, that I'll explain.
ठीक है. The learned counsel has also submitted that in such circumstances there is no need to stay further proceeding. However, there are other parties as well in the execution proceedings.
Only he will be
Many other
affected.
parties are there.
Appellant will be affected. Otherwise, what has happened? Defendant number 2 did not. In fact, she submitted her WS in my favor, in favor of the plaintiff, acceding to my claim.
You were the sole plaintiff.
Yes.
After hearing the learned counsel for the parties, the matter is directed to be posted for final disposal on Monday.
Tuesday को करते हैं. Monday थोड़ा सा हमको difficult. एक केस हमारा fix है.
Monday, Tuesday.
आपके लिए 9 को.
With the consent of the parties.
Yes.
Holds this case for final disposal on Tuesday, to be taken up at 10:30 as first case. Till Tuesday, the further proceedings in the execution case shall be maintained. Communicate.